sheet right here. If you're not able to do it now, definitely before you leave, make sure to stop by and make sure you check in with us. So
I also posted the link in our
yes, if anyone's in the group me, you'll see it there as well. If you're not in the group me and would like to join, talk to one of our executive board members. So hi everyone, I'm Michael Moore. I'm the president of the Federalist Society. Very excited to see everyone. This has easily been our largest event to date, our second event in person in quite some
Who was
time.
first? I thought I was first.
No. So it was Chance Weldon from Texas Public
All right, I
Policy
chanced a friend. He can do it. That's fine.
So this was our second event. We're very excited to be here. I think we're going to have a great conversation, great Q&A period, and really have some great conversation. So a few announcements. We have one more event coming up this semester. We have a judicial panel coming up on Monday featuring Judge Brown from the Southern District of Texas and Justice Rebecca Huddle from the Texas Supreme Court. So that'll be sure to be a great event. And then if you are interested in joining our group me or interested in leadership within the chapter here, reach out to one of our members. We're certainly looking to, for anyone to jump on board that has fresh ideas, that wants to take on leadership, now's a great time to do so, especially as we lead into elections in the spring, where any leadership taken now can really help position you for a great election season. So any questions about the Federalist Society? Okay. So we are going to have a great discussion today. We have two esteemed professors who are going to dig into the previous Supreme Court term and offer their insight. So I'm going to introduce each of the two, and we're going to start with Professor Blackman after introduction. So to start, Professor Josh Blackman is a national thought leader on constitutional law and the United States Supreme Court. Josh's work was quoted during 2 presidential impeachment trials. He has testified before Congress and advises federal and state lawmakers. Josh regularly appears on TV, including NBC, CBS, ABC, Fox, and the BBC. Josh is also a frequent guest on NPR and other syndicated radio programs. He has published commentaries in the New York Times, Wall Street Journal, Washington Post, and leading national publications. Since 2012, Josh has served as a professor at the South Texas College of Law. He is also an adjunct scholar at the Cato Institute. He has authored 3 books. His latest, An Introduction to Constitutional Law, was a top 5 bestseller on Amazon. Josh has written more than 6 law review articles that have been cited nearly 1,000 times. Josh was selected by Forbes magazine for the 30 Under 30 in Law and Policy. He is the president of the Harlan Institute and founded Fantasy SCOTUS, the internet's premier Supreme Court fantasy league. He blogs at the
You should all play.
blogs at the Volokh Conspiracy and tweets at Josh.
Did you mention which law school I teach at?
What's that?
Did you mention which law school I
I
teach
think
at?
I did.
You did? Okay. I teach the other law school across 45, South Texas College. This was my favorite one to come visit because it's very close.
And I'll introduce our other speaker briefly.
Might be an injunction against mentioning the name of my law school, though.
So Professor Seth Chandler is a Law Foundation Professor of Law at the UH Law Center, who specializes in insurance law and the application of mathematics and computer science to law. Professor Chandler won a prestigious university-wide Teaching Excellence Award in 1995, was a first-year winner of the Innovator Award from Wolfram Research, received the President's Medal from Loyola University for his extraordinary service in the aftermath of Hurricane Katrina, and has been called on twice to testify before Congress on the Affordable Care Act. Professor Chandler has a broad internet presence. He's the author of over 100 interactive demonstrations, 21 resource functions, and several data repositories on the Wolfram Research website. He founded 2 blogs, acadeathspiral.org, which addresses the ACA, and catris.net, which address catastrophic insurance in Texas. Professor Chandler's blog entries have over 400,000 views. He practiced with Munger, Tolles, and Olson in Los Angeles, and Williams and Connolly in Washington, D.C., before beginning his academic career in 1990 at the University of Houston Law Center. Professor Chandler teaches contracts, health law, analytic methods, and constitutional law. So at this time, we will start with Professor Blackman.
Thank you. Thank you so much. It's a pleasure being with my dear old friend, talk about a Supreme Court term. The Supreme Court is very much in flux. Precedents that were deeply rooted and long established are no longer deeply rooted and firmly established. The court is moving in a fairly fast direction to reverse many of the decisions, not necessarily from the 50s and 60s, but really the 70s and the 80s. That's the sort of entrenchment we're seeing. So I want to focus on three fairly boring topics: abortion, guns, and religion. I think Seth will round this up with the interesting stuff. So let's start with abortion. How many of you took con law last year? I'm really sorry. You're gonna have to take it all over again, right? So the basis of modern constitutional law focuses on something called substantive due process. This is a notion that the due process clause protects certain types of liberty interests, and the court has used this to extend to things like interracial marriage, contraception, abortion, same-sex relations, same-sex marriage, and a few other contexts. There was never a single explanation of why certain rights were protected, but the courts looked at things like dignity. They've looked at things like emanations and penumbras. They've looked to things like uh, liberty, defined very broadly as the absence of government. All right. But that entire framework, I think, has now sort of been cut off. Last term, the court decided a case called Dobbs v. Jackson Women's Health. This was a case from Mississippi. Mississippi, our friends to the east, enacted a 15-week abortion ban. That ban squarely conflicted with Roe v. Wade. It squarely conflicted with Planned Parenthood versus Casey. The express purpose of this law was to challenge Roe in court, to create what's called a test case or a vehicle to challenge a decision. When the law was enacted, it wasn't clear that there were 5 votes to overrule Roe. Indeed, there probably weren't. But by the time the case got to the Supreme Court, there were a total of 6 Republican appointed justices, and 5 of them voted to overrule Roe and Casey. Now, what's significant from the perspective of constitutional law is how the court will now go about doing substantive due process. Justice Alito's majority opinion was very clear. We will only protect those rights that are deeply rooted in text, history, and tradition. I think the court showed that abortion did not fit into that framework. The dissenters, Justices Breyer, Kagan, and Sotomayor, didn't really disagree. They argue that rights should not be frozen in time, that we should look to precedent and modern conceptions when defining rights. But the majority said, no, we're not going to do that. And more importantly, the majority said, abortion will be an issue for the democratic process. It'll be for the voters to decide. Indeed, Seth, we had an election last week, didn't we? I think a lot of voters did decide to vote on the basis of abortion. It didn't really work to the benefit of Republicans in about any state in the union. Even in Harris County for our judge election, abortion was a big issue. You know, they have no power over abortion, but there was an issue that energized voters. So perhaps in that limited regard, the court's abortion decision signaled a shift in constitutional law on substantive due process. Okay. The second major area I want to talk about now is guns. I'm sure many of you studied in con law, District of Columbia versus Heller. This was a 2008 decision that held the Second Amendment protects an individual right to bear arms that's not connected to militia service. And 2 years later, we had McDonald v. City of Chicago. This case held that the Second Amendment is incorporated. That is, it extends to the states and also limits state governments. But Heller and McDonald only governed the right to keep a handgun in the home. It left open the question of whether you have a right to carry a handgun outside the home. And for nearly a decade, there was lower court litigation on a right to constitutional carry. Most circuit courts said that, yes, there might be a right to carry, assuming there is one, but the state can heavily restrict it. That is, the state can require you to show proper cause. That is, I have a special reason of why I have a carry license. It's not enough to say self-defense. You must show something more. It's a standard, not a rule. There's discretion, as we say in the law. 1 or 2 circuits held that these regimes were unconstitutional, but the Supreme Court never granted certiorari, never granted review on any carry cases until last year. New York was one of those regimes with what's called a may issue licensing scheme. That is, they may issue a license, maybe they won't. It depends on whether you meet the subjective judgment of some government official. There's no clear standard. If you were, friends with a sheriff, you'd probably get your permit. If you were a politico, if you were a celebrity, you know, you probably got your permit. But if you were a regular person living in Rensselaer County, upstate New York, you were denied your license. So this case goes to the Supreme Court. And there's a tension, and I just want to sketch this out for you for a moment, right? In the abortion decision, the court says abortion is a matter for the political process. Let's get the courts out of this area. Okay. But in the gun decision, they rule in favor of the individuals. They rule against the state, saying, well, abortion, not for the courts, but now guns are. So in the same term, the court sort of injects itself further into gun control litigation, but withdraws from abortion litigation. Now, of course, the court would say, well, that makes sense because abortion is in the Constitution while guns are not. Not everyone agrees with that. Oh, see, that's why he's next to me. Abortion is not in the Constitution. You know what I meant. Abortion is not in the Constitution while guns are in the Constitution. And that would be the distinction that the court would draw. And then we vigorously disagree about how we define constitutional rights. Now, what's fascinating about the decision in Bruin is there was a debate about history, right? The majority, let's start with the dissent. The dissent demonstrated that there were instances throughout the last, 800 years ago or so, where the government was able to restrict carry of guns in public, going back to the 1300s, or some laws that says you cannot carry arms to terrorize others in a king's dominion. Back in the jolly old England days, the majority says, well, that's not close enough because those are people who terrorize, or you might call an assault or brandishment. You use your gun to scare someone, but merely peaceably carrying a gun did not fit into that mold. And there was this vigorous debate about this history. Justice Thomas wrote the majority opinion. He came down to this point. The history must clearly show some history and tradition of banning carry by peaceful citizens. Unless you have that clear, unequivocal historical evidence, the presumption goes to freedom. The presumption goes to the individual that he can carry arms. So as a result of the Second Amendment decision, Bruin, states now, in theory at least, are required to grant licenses to people. But states are actively resisting that ruling. New York passed a regime, which is not going to fly. I'll see what Seth thinks, where they require people who apply for handgun licenses to submit their social media accounts so that people can scan their tweets and their TikToks, see if they have any hateful speech. I don't think it's going to work. They require references, that is, people must actually attest to their character. I don't think that's going to work. Other states are getting involved with mental health checks. We say, well, of course, people with mental health issues shouldn't have guns. Well, I want to ask this question, but how many people have been to a psychologist before? A lot of us. And I can tell you in New Jersey that if you say, yes, you've been to a mental health professional, they want records. Ugh. They want actually a record from your psychologist or your mental health professional attesting to your state of mental acuity. Now, keep in mind, those are privileged records. We don't like giving our mental health records to the government. So even if you hate guns, which you might hate guns, this is very risky. Have you ever been on, an antidepressant, even for a period of time, 20 years ago? Should you be deprived of civil right indefinitely because you had, a bout of depression after your mother passed away? So again, the states are trying to resist as best as they can the Supreme Court's ruling. I think a lot of these measures will not work, but it will take years to sort of filter through the litigation process. All right, so I did abortion. I did guns. Let's do religion. Now, if there's one issue on which the court's conservatives agree, lock, stock, and barrel, it's religion. And we have two clauses of the Constitution. We have the Free Exercise Clause and the Establishment Clause. For much of the 20th century, the court read the Establishment Clause as a very strict guard to keep this wall separation between church and state. That was what we all learned in common law growing up, like Seth and me did. And the lesson was we must have this separation to avoid religion creeping into the public sphere. And we get all these tests. We get the so-called Lemon test from Lemon v. Kurtzman that says you cannot have an entanglement between church and state. We have the coercion test that the government can't coerce into religion. We have the endorsement test. The government cannot endorse religion. And then we have the purpose prong of Lemon, that the government acts with an improper purpose, it's invalid. So we have like this hodgepodge of tests, which the court seems to apply almost at random. No more. The court has signaled no mas to that. We are now going to get rid of the lemon test. No more purpose prong, no more entanglement prong. And instead, we will use what's called a text and history and tradition approach, sensing a pattern. With abortion, text, history, and tradition. With guns, text, history, and tradition. With religion, text, history, and tradition. It's remarkable that in one term, these three major areas of constitutional law have been rewritten almost overnight. So there were a couple of cases that were involving religion. One, Coach Kennedy. Coach Kennedy was a football coach. He was actually an assistant coach, but that's fine. And when I see someone with Katie football on his shirt, assistant coach is still good. Yeah, assistant coaches do a lot of work. I live not too far from Katie. So Coach Kennedy would do something unusual. After the game was over, he would go to the 50-yard line, he would kneel, and he would say a quiet prayer. He would often be surrounded by players on his own team and some players on the opposing team. The high school, which is a suburb of Seattle, said, no, stop it. You're not being paid to pray. Stop this. And we don't want to get sued for violating the Establishment Clause. Just stop this praying. And he would not. Kennedy later brought suit against the university or against the high school for basically punishing him for exercising his speech rights. So this case was basically a free speech case. He said, I have a right to speak and pray in public at the 50-yard line after the game was over. But lurking in the background was the Establishment Clause, because the school said, we are not going to let you speak. We're going to violate your speech rights to avoid coercing football players to pray with you. Because you imagine if you're on the bench and you want to get more playing time, you might feel some pressure to pray along with the coach. As they say, pray to play, right? That's supposed to laugh at that one. Thank you. But the court said no. Unless there's evidence of direct coercion, the language Gorsuch used, direct coercion, there's no Establishment Clause violation. Direct coercion, wow, that's a high standard. In other cases like Levy-Weissman and Engel versus Vitale, even indirect coercion for students, just feeling pressured a little bit might be enough to violate the First Amendment. No more. All right? So the court is saying, yeah, the separation of church and state, we're not using that anymore. So unless there's a history of actually banning prayer in school, banning prayer after athletic events, you can do it. What about funding for schools? We have the great state of Maine, Carson versus Macon. Maine has a weird policy that if there's no public school in your area, the state will give you money to go to a private school. Makes sense, unless the school is religious. Unless the school is religious. If the school is religious, you don't get your money. Why the school of that policy? They were trying to avoid a violation of the separation of church and state. They want to avoid entangling the government with the religion. No more. The court says denying the funding to the school is itself a violation of the Free Exercise Clause, right? It's a discrimination on the basis of religious status. Even if the money's being used for religious purposes, imagine they're buying Bibles with that money. Still, you cannot deprive the school of that funding. So in these two cases, Kennedy and the main case, Carson versus Macon, the court said, even if you're afraid of violating the separation of church and state, you cannot infringe on religious speech. You cannot infringe on religious exercise. These two rulings, I think, have dramatically rewritten the scope of how governments interact with religion. 30 years ago, I would have said that funding this school in Maine would have been unconstitutional. 30 years ago, I would have said that allowing the coach to pray at 50-yard line would have been unconstitutional. And today, it's the opposite. Depriving the school of the money is unconstitutional. Denying the coach the right to speak and pray after the game is unconstitutional. So we've almost inverted the way we look at religion, where in the past, religion had to be sort of eschewed and kept at an arm's length. And now, if you do that, you're violating the constitutional rights of people of faith. Right? So we have abortion, we have guns, we have religion. In all these areas, of course, taking a more historical approach to the Constitution. And really, we're in somewhat uncharted territories. Now, are you teaching common law this semester?
Next.
I am not teaching common law this year. I'm actually glad. I want to see how things shake out because we don't quite know where things are going. This year, it's not to talk about maybe affirmative action, election law, and some other hot topics. We have a lot of changes. In fact, I have a common law case, which I think Seth has used in the past. We're up, we're speeding up our next edition, right? We weren't supposed to publish till 25. We're doing it 24. We're moving our next publication cycle up to account for these massive changes in constitutional law. All right, I will stop here and turn it over to my good friend Seth, and I welcome your questions later. Thank you all so much. You mind put computer time?
Yeah.
Yeah. I unplug it, the thing will go away. I'll just put it over here. Okay. Okay, that should work.
Okay, well, hi, folks. So I think actually the most important thing I have to say is that the most important thing is that this event is happening. It's really important to have a diversity of views at a law school. And so I'm often very glad to appear at Federalist Society events or ACS events. I think it's just very important that people get to hear views that challenge them. This year, though, to be honest, I have some mixed feelings because I'm not happy with some things I see going on at the leadership of the Federalist Society, not perhaps at the ground level here, but it's kept in, for example, as I understand it, John Eastman, who engaged in, I think, reprehensible conduct, and it has not really, I think, policed itself to the extent that it should in getting rid of people who I don't think share constitutional norms as I do. So I'm here, I'm going to talk, but I will say I have to think a little bit about Federalist Society events in the future, which I think is a shame because I do think it's very important, as I said, to have diverse views at law schools. So I'm going to try and fill in some of Professor Blackman just talked about a lot of things I want to talk about, and we agree on many of them. So let me just fill in some gaps here. The first thing is with respect to Dobbs, the abortion case. One of the things that's interesting, I think, is that, first of all, you've seen some political consequences, but apparently, although it may be costly to do so and annoying to do so for some people, it has not, at least according to some of the statistics, had the effect on abortion that many people hoped it would have. That is, abortions are not down all that much from the limited statistical evidence that we have, and there are issues with that evidence. But I think what you're going to see is a push from conservatives to go further, to, for example, prohibit people from traveling interstate for the purpose of procuring an abortion, to prohibit people even more forcefully from taking medications that induce abortion. And I think really the new frontier is how willing is the Supreme Court going to be to uphold those further restrictions in those states that enact them. You saw Justice Kavanaugh signal in his opinion or his concurrence in Dobbs that he wasn't on board for further restrictions, but we'll see. Finally, on abortion, the question is, okay, so they basically trashed Griswold-style substantive due process, for those of you who remember that opinion. And the question is, what does that say about Griswold itself, which deals with the right to contraception? And what does it do with other opinions that rested, at least in part, on substantive due process, such as Obergefell, which prohibited states from barring gay marriage? The short answer is, I don't think there's a political constituency to prohibit contraception, and so it'll be curious to see whether that case ever gets to the Supreme Court. With gay marriage, I can tell you that that opinion rests on two bases. One is substantive due process, the other is equal protection, and that Dobbs did not really address any equal protection issues. And so I would suggest that gay marriage, although I understand why people are concerned about it, is probably safer right now. There's another abortion decided last term called Jackson versus Whole Woman's Health, which dealt with SB 8, a bill here in Texas, which created civil liability for either performing an abortion or aiding and abetting in the performance of an abortion. And the Supreme Court basically said, if you want to raise the unconstitutionality of abortion, go do it defensively when you're sued. Okay? You can't bring an affirmative case because who are you suing? You can't sue the private parties who might at some point in the future sue you for having committed an abortion. So California, for example, has enacted a law which creates an SB8-like scheme for guns. And the question is, is Jackson just sort of a one-off weird case, or does it open the door for states who don't like certain civil liberties for creating private civil remedies for them? And that remains to be seen. If you ask me today, is Jackson versus Whole Women's Health as a practical matter an important case? I might say not really, but it might become. All right, let me talk about another case. This is one that Josh didn't mention, West Virginia versus EPA. It's not a con law case, uh, really, but it's an important case for two reasons. First of all, regulation of greenhouse gases is important, which is what the case was about in part. And the second is it's revitalizing this major questions doctrine, this notion that we're not going to give agencies this broad discretion to take some statute and turn it into something that was perhaps never intended. And you can see, I think, the major questions doctrine as a backdoor rebirth of what used to be the non-delegation doctrine, the notion that agencies would have to seek clear authority from Congress. That doctrine has been pretty moribund for the past 80 years, 90 years. But it's sort of been rebadged as the major questions doctrine. And it's, by the way, what's at the center, once you get past the standing issue, of the debate about Biden's student loan relief plan, where he decided to, or the agency decided to take a statute perhaps designed for other purposes and use it as a basis for costing the government $400 billion. So we'll see if that later dispute gets to the Biden's case. The Biden loan case gets to the Supreme Court. On Carson versus Megan, I do think that's the big case in the religion field that was decided last term. That's the case in which the Supreme Court said if the state is going to give money to parents to let their kids go to private school, it has to give them an equivalent amount of money to let their kids go to secular school. You're already seeing states other than Maine, notably Arizona, take advantage of that and saying, hey, we want to use a broad voucher scheme. And as part of that voucher scheme, yeah, you want to send your kid to a religious school, that's fine. I think this is a very important decision because I think there are a lot of communities which would like to see money go to private schools. And if it went to religious schools, perhaps all the better. So one of the questions is, to what extent does the decision in Carson extend beyond schools? What if the state wants to privatize provision of some services like transportation? Does it have to then equally subsidize a bus, for example, in which women have to be seated at the back or on separate sides as men? There are all sorts of interesting issues that flow out of Carson versus Macon. On the New York State rifle and pistol versus Brune, the gun case, what I would add is you are seeing massive resistance from states who are just not happy with that decision. I agree with Josh. This is going to take years to work out, but just as you saw massive resistance in the 50s and 60s to various integration decrees from states that didn't think that that was right, you're going to see massive resistance in states like New York, New Jersey, et cetera, fighting the right to bear arms. The other case I want to bring up from last term, I don't know whether you count it as con law or not, but there was a really important Indian law case decided, Oklahoma versus Castro Huerta, in which the Supreme Court gave additional authorities to states to regulate behavior on reservations. And it's important both because in some states like Oklahoma, reservations comprise, a substantial portion of the state. The other thing is, not only was the Supreme Court willing last term to overturn decisions from the 60s and 70s, in Oklahoma versus Castro Huerta, they at least issued a decision in strong tension from Chief Justice John Marshall's opinions back in the early 19th century regarding the relationships among federal, state, and Indian tribes. So an important decision. Let me spend a few moments on what's coming up for 2023, the coming term. We have, I think, two big questions on elections. And ultimately, at bottom, I think if you have to say, what are the most important cases the Supreme Court decides, they're just cases on elections, because you can kind of see that elections are important, and they in turn affect both judicial decisions, political decisions. We've got one Moore versus Harper on what's called the independent state legislature doctrine. The Constitution says, with respect to the Electoral College, each state shall appoint in such manner as the legislature thereof may direct a number of electors, blah, blah, blah. Notice it doesn't say, it could say, each state shall appoint a number of electors. It doesn't say that. It says, each state shall appoint in such manner as the legislature thereof may direct a number of electors. So the question is, what role is there for the state judiciary to challenge under a constitutional or state constitutional bases decisions made by the state as to their system for choosing electors? Okay, it's the position of what state is it?
North Carolina.
North Carolina. Thank you. That it means legislature, doesn't mean the judiciary can interfere. If the Supreme Court were to agree with that, that potentially gives state legislatures a huge amount of freedom, not only in conservative states, but one could imagine liberal states joining the bandwagon or retaliating by using their own methods. The other case that's before the Supreme Court, which has been argued, is Merrill versus Milligan. It's on this issue about the requirement under the Voting Rights Act to create what are called majority-minority districts, districts in which there's polarized voting patterns based on race, and which if you draw the state lines one way, minorities will have a majority in a small number of districts, a larger number of districts. What are the obligations under the Voting Rights Act? All right, we've also got two cases related on affirmative action before us that are basically going back and challenging this notion as to whether to what extent does the state have a compelling interest in diversity in these are both higher education cases, and what obligation is there to search out alternative methods for achieving diversity. What I'm going to tell you is Josh's site, he runs this fantasy SCOTUS, and it does predictions. People bet
Yeah, how's it looking at that?
People bet on how the case is going to come out.
They don't bet money because that would be in the illegal. So they
Okay, they bet their sacred honor. They
yes,
bet
their fortune, their sacred honor.
On it. Anyway, if you have a mathematical bent, as some of us do, you can take the individual judge level predictions there and aggregate and try to figure out what's the probability of, a 5-4 decision, a 6-3 decision, etc. I did the math, and when I last looked at Josh's site and took the data, there is an 86% probability that the cases are going to be reversed. That is, that affirmative action is going to be in deep trouble following this term. Exactly how much trouble will depend on how they write the opinion. But I think, just as there was a huge amount of controversy over the abortion cases, I would expect to see sometime in June, possibly sooner, since it was argued sooner, considerable controversy about a substantial demise in a requirement or ability to have affirmative action. A few other cases, and then I will leave time, certainly leave time for questions. We have an exciting dormant commerce clause case coming up involving regulation of pork by California. And we will see what the Supreme Court does. There's sort of there are justices who don't believe that the dormant commerce clause really exists. On the other hand, those justices might not be too happy about California's aggressive regulation of the conditions of pigs around the country. We've got another Indian law case before the court, Hayland versus Rakeen, which is it's a complicated case. It's about something called the Indian Child Welfare Act, which in my con law case, at least we read about in a case called Adoptive Couple versus Baby Girl. And it's about the extent to which state courts have to give preferences in adoption and fostering procedures to either Indian tribes of the kid, that is, the kid might belong to the Cherokee tribe, but even if the tribe isn't interested, maybe there's some other Indian family who's interested. It raises questions about something called, well, it raises questions as to what are American Indians. Are they a racial group, an ethnic group, a political group, which is how they were characterized in 1974. It raises questions about commandeering of state and the scope of the Indian Commerce Clause. Finally, I have one more I'll add and then I'll be quiet, which is the 303 Creative versus Alanis case, which is about whether a state can obligate, in this instance, a web designer, but really applies to any business in Colorado, a web designer to build a website that will be used to support, to foster a gay marriage, as an ancillary to a gay marriage. The last time this ordinance or this law in Colorado was before the court in a case called Masterpiece Cake, they found a clever way to evade the issue by claiming that some of the participants had shown a bias against religion, which, had they actually shown that in a major way, might be problematic. This time, the procedural posture is different. The court does not have that way out. And so we're going to see a conflict between, I would say, the civil right interests of people participating in gay marriage versus the political speech rights or the political action rights of people who don't support gay marriage. And then there'll be a question, by the way, as to, okay, right now, what if I don't support interracial marriage? Can I take an interracial couple and say, I'm not building a website for you? Can the state force that person to say, no, you can't discriminate on that basis? So those are some of the issues before the court. I, personally speaking, since I didn't really have much to disagree with in what you had to say, I think it would be better if we just went directly to questions. If there's something that you want to comment on.
No, I'm happy to, and I think we have to average 12:50, so I'm happy to, 12 minutes, or happy to go to questions. Yes, sir. Well, let me answer it this way, right? If we're only protecting those rights that are deeply rooted, odds are they're not laws infringing those rights. Generally, the sorts of reason why you would need substantive due process is for things that are not currently protected. It's a forward-looking things that come around, like gay marriage, which didn't exist 20 years ago. Now it's a very common common arrangement. So I don't know that's dead. I think it just won't protect any newfangled rights. Now I'll put the question to Seth Lochner. There's a very deeply rooted interest historically in a right to economic liberty. Heck of a lot stronger than the right to abortion. So, there was a concurrence from Judge Ho in the Fifth Circuit last week suggesting if we're going to do substantive due process and say we'll protect deeply rooted rights, what about economic liberty? The court's modern rational basis test is an innovation of the Warren Court, right? In Williams v. Optical, where we treat economic rights as secondary. I don't know. Do we go back to
you can go back to Caroline products, right?
I'll take Caroline Products over Lee Optical.
Okay.
Caroline Products is fine. It's Lee Optical.
I think substantive due process is dead. I think it's going to be, I agree, it's going to be extraordinarily difficult to create new rights under the court's standard. Does that mean that I think they're prepared? If a state were to go full Handmaid's Tale and ban contraception.
Oh man.
Okay.
And forced conscription, forced carrying children. Yeah.
Would the court overturn Griswold, or would they figure out a way? And my guess is they would figure out a way to protect it, but they really, what's the polite way of saying it? They did not view substantive due process with favor. And so it gets hard to resuscitate it if states behave in unusual, peculiar ways.
Very good. Other questions?
Do you guys think the new standard set out in Bruin killed the chances of any potential future assault weapons ban being upheld?
I guess I'll start on this. I am not personally a big fan of history tests because, and this is an old critique, there's nothing novel with me, but It's like, how do you try to figure out what the founders would, and which founders would have thought about if they imagined a society which was completely different from the one that they lived in? Like, I understand you could extrapolate a little bit from the society, but they did not have, I mean, I know this is not a very popular argument, but at the time, there were muskets. And the largest population city, I think, had 30,000 people, maybe 50,000 people. There was not, it's a very different world. And so I have a hard time saying how you can get a determinate result out of history. Now, I'm in the minority because that's what we're supposed to use, and it's supposed to be less manipulable than the more, touchy-feely approach of the Warren Court. But I'm not sure how impervious it is to manipulation because of the ambiguity often of historical sources. But even where those sources are clear, trying to get into the heads of the founders and figure out what they would do about today's world, I think is a very hard matter.
So the question is, would a federal, because you're in a second, would a federal assault ban be constitutional? How many people know what an assault weapon actually is? What does it actually mean?
It's like a meaningless term, and it was previously defined as like attachments
It,
on a
it
rifle.
doesn't actually decide how powerful the gun is. It's a misconception. It refers to cosmetics, various attachments and bolts and lug nuts and grips and things like that. So there's actually arbitrariness there. Why are these provisions banned and not others? Putting aside the Second Amendment. So I think the political will is simply not going to be the part of the constitutional will as well. Yes, in the back.
This is slightly, but it really is real quick. You see a cottage industry of PhDs in history finally having jobs to be images, curiae, like writers, things like that. You do some local research for these arguments that are going to go before appellate and Supreme Court.
Sure. Yeah, I mean, but the Supreme Court doesn't like the historians. So you have all these historians who come out on the side of Justice Stevens and Heller and Justice Breyer and Heller. And, there's a vigorous debate, which I can't get into much today, about the role of historians versus the role of originalists. And they don't always agree. And in some regards, they're very different enterprises. Historians are trying to tell sort of a story about historical context, how things are understood. Originalists are trying to give meaning to phrases used in text, and they're inherently different tasks. I don't have a degree in history. I don't pretend to have one. Originalists, I mean, historians think that I have no business talking about this history, but I can do legal research. Now, Seth, I think, is a fair point that it's manipulable, perhaps, might be indeterminate. But whether you like it or not, that's the world that we're living in. And now judges are going to be conscripted to sort of think about these issues. But the one thing that makes it easier is Justice Thomas put a thumb on the scale. He said there has to be clear evidence, a clear tradition of this sort of regulation. If it's not there, you can't ban it. So the upshot is this is a very libertarian standard. If they don't have a history of this sort of governmental regulation, you can't do it. Even though New York's law was over 100 years old, right? It was from the 19 teens. It's a 110-year-old law, but that's not old enough. It's going back further.
I'll give you a semi-facetious answer to your semi. So, in the field of insurance law that I teach, there's been all this asbestos litigation, and some of the states have said that if you were exposed, it mattered when you were exposed to the asbestos. Well, some people were exposed to asbestos in the 1930s and 1940s, and the issue is, was there insurance coverage? Well, by 1990, who knew whether there was insurance coverage back in the 1930s? And so a field developed called insurance archaeology. And at least for a while, there were more insurance archaeologists in the world than real archaeologists. And so where there's an incentive structure created where that history becomes important, you could see, yes, I do think actually it is going to give employment to historians. Maybe that's could be a good thing for a variety of reasons, but it turns out under the current system that history really does matter. So yes.
Okay, another question. Yes, ma'am.
Hypothetical question: if the Harvard and Yale theses are cited in a way that is not favorable to their current policy, so we can't, consider further action for. What effects might that have? I know they're saying it's strictly confined to school admissions, but what effects do you think that might have, or a way that it might spill over into, say, private sector employment decisions?
Oh yeah, that's for you.
All right. So the first thing I would say is the court's already drawn it's
Yes.
drawn somewhat of a distinction between purely commercial, like guardrail construction, cases where it doesn't see much of an interest in diversity and minority contractors and the like, where in the education setting, it's stronger value in diversity. The employment setting is an interesting mix, isn't it, in public employment. That is, if you believe, as many people do, that diversity leads to better decisions, okay, more profitable decisions for a business, or in a case, I guess, of a government, better policy choices, whatever that is. That interest still exists. The question's going to be, as I think it is in the Harvard and the UNC cases, are there ways other than racial preferences whereby you could achieve roughly comparable levels of diversity? And this is where it all gets complicated, because then what do you mean by diversity? If you want to achieve racial diversity, in my opinion, the best way to achieve racial diversity is to choose things based on race. That seems like pretty direct, rather than using things that are statistically correlated with race, but aren't race itself, like, first time in college, or income, or other things that correlate in modern America with race, whatever the heck race is. My guess is, first of all, I think Harvard is due.
They're toast. Toast. They're toast.
Yeah, as a Harvard alumnus, I think their record, if you look at the statistics, it's really bad.
Yeah.
What they were doing to Asian Americans,
Mhm.
which they lumped together as a category, which probably shouldn't be a category. UNC might be a little closer, both because you have one more justice on the case than you do in the Harvard case, where Justice Brown has recused herself. But I think the court is likely to go on a narrowly tailored basis, and to say that really is strict scrutiny. You've got to really, really show that you have looked at all other alternatives, and that you really have a strong factual basis for saying diversity helps in your setting, and that you haven't tried other methods of achieving whatever that diversity is. And so what I think it's going to mean, by the way, both in the academic setting, where there's going to be massive resistance in many states to a ruling saying affirmative action is dead, including this school, by the way.
Yes, sir.
Is you're going to see decisions get completely fuzzified, where it becomes incredibly difficult to figure out why the school or why the employer is admitting someone, because it's very difficult to disentangle in modern America race from all sorts of other factors, and it's very difficult to figure out why people make the decisions that they do. So that's my answer.
There'll be massive resistance to this ruling. Seth is exactly right, and I cannot wait for the discovery.
That is all the time we have. Let's give a round of applause to our.
Thank you, Seth.
So the next class comes in at 1, so we do have to get out. You have conversations, you can start